My lords, my lady, before I move back to the grounds, it's worth just updating the court on a development this morning. At 9:35, we received two documents from the other side, the promised analysis of different strands of reasoning in the judgment, now the focus being only on two judgments rather than the previous three. And then also separately, a table which identified the Maduro Board's position in relation to what is and is not being challenged as a matter of findings of Venezuelan law by Mrs. Justice Cockerell. And that second document contains a new concession that no challenge is any longer being pursued in relation to the correctness of the learned judge's conclusions that there was no procedural route available to my clients to challenge the STJ rulings.
Right.
And obviously, well, on any view, that narrows the scope of dispute, but we say it's actually decisive of the entire appeal when one looks at core tab 1, page 17.
Yes.
This is the grounds of appeal for which the Maduro Board has permission. And one sees in relation to the third ground, natural justice, from 4 and 5, that the only basis being advanced under the natural justice ground in this articulation of the grounds is related to domestic remedies. So one sees at 5.1 that the error identified by the judge is that she ought to have found that domestic remedies were available as a matter of law. That factual challenge as a matter of Venezuelan law is no longer being pursued. Therefore, 5.2 doesn't apply, and therefore 5.3 can't apply either. And so our position, I'm not sure that Mr. Lissac recognises this, but our position is that the appeal is effectively now over as a result of the morning concession. Obviously, I'll move on to consider the grounds, but given the significance of that concession this morning, I ought to raise it.
Yes, all right. Well, I think you're ahead of us because we, at least I, haven't seen those documents. But I'm sure they'll wend their way to us in due course.
Yes, we were going to hand them up. The learned friend didn't mind, but some in his team hadn't had a chance to consider the documents, so we thought it more courteous to them to wait and allow them the opportunity to see them before burdening you with them.
Of course, that's absolutely fine.
Thank you. Thank you. We can hand them back at a convenient time.
Yes. In which case, then we move back to finish off one voice, ground 2. I need to deal with Mr. Lissac's new point about post-trial changes of circumstance. Part of the reason I come to it last is that we do take a procedural objection to Mr. Lissac even running this point. He and his enormous legal team supporting him must know that if you want to rely upon new facts or legal arguments, then you need permission to do so. The Maduro Board was in a position to take this new point from right back in January 2023, when they received the letter from the government legal department that the recognition of Mr. Guaidó was withdrawn. It can't have escaped their attention that might have a bearing on the issues. They could have made an application at that stage to say they wanted to introduce this as a ground. And I don't understand why Mr. Lissac thinks that he is free to rely upon these new arguments about post-trial events without having sought permission to expand.
Well, I did ask Mr. Lissac, well, I did say to him, this is legal ground of appeal.
Yes.
I didn't yet hear any answer to that.
My Lord, no.
As far as fresh evidence is concerned, there's no application for any fresh evidence, but I suppose it might be said that the further letter from the government we should accept. You wouldn't normally need to put that sort of letter in evidence, would you? Maybe?
My Lord, no. We fully accept that the court's going to take a benign view of matters which are relevant to the determination of the appeal, which update the position, and if we obviously wouldn't resist a letter like that, which updates the position. Indeed, it would be completely inappropriate for me to stand here making submissions as though that letter didn't
But
exist.
certainly, but you could expect that any argument based on it would have been formulated in a ground of appeal and a skeleton argument.
Exactly that. And we simply don't see why that hasn't been done. It so happens that we haven't been caught entirely off guard because that we have been able, in the context of the stay application, on which Mr. Lissac failed, to engage with some of these points of principle about the relevance of the time period at which the one voice point is engaged. But when Mr. Lissac referred yesterday to my submissions about this, they weren't my submissions in an appeal skeleton, they were my submissions in a stay skeleton. And this hasn't been properly ventilated in the context of an appeal. And it's rather more... Sorry, Noel.
No, I was only thinking to myself that you said yesterday you were going to deal with this point in about 5 minutes, from which I inferred that even though it's not in a skeleton argument or ground of appeal, you considered that you were in a position to deal with it.
Well, I'm still hoping to, Noel, yes. but the only other point I wanted to make about the procedural objection is that this is not, as some similar points might be, an arid procedural point, a pleading type point, because one's in the territory here of sensitive matters of UK foreign policy. And if the point about one voice had been ventilated at the proper time and the significance of the HMG withdrawal of recognition, then it's entirely possible that the FCDO would have wanted to make submissions and take a position in relation to this. And indeed, they could have killed the point dead by issuing a new, fresh certificate of explicit non-recognition of Mr. Maduro. Or they could have made legal submissions of the sort that I'm about to make in hopefully less than 5 minutes, about why the point's a bad one, but the court may have wanted to hear from the FCDO. The FCDO may have wanted to say something. And again, this is not just a dry procedural objection. This is a matter of some potential significance in the context of UK foreign policy. And in that regard, we do say there's an unfortunate echo of what happened when we were before the Court of Appeal in 2020, when two of the members of the panel may remember that the Maduro Board sought to run a international law challenge that had been unpleaded, unventilated, and not notified to HMG. And as I anticipate the court is about to do now, we'll move on to consider it as to its merits, but quite rightly, at paragraph 131 of that judgment, which I'm afraid isn't in the bundles, the conduct procedurally of the Maduro Board in that regard was seriously deprecated. And so we do object to the cavalier approach to procedure. It's not how an appeal to this court should be run, particularly not when, as Mr. Lissac is fond of reminding everyone, this case is of such immense geopolitical significance and financial value. But, my Lord, I will deal with it, and I'll deal with it quickly, because we say it's entirely wrong. What the one voice principle is concerned with is the need for consistency between the judiciary and the executive when identifying who at any relevant time is exercising the sovereign power of a foreign state. The relevant time can be the present day, in anticipation of that position continuing into the future, or it can be backward-looking. And we gratefully adopt the formulation by my Lord Justice Mayles yesterday. In order to see how the one-voice principle works, one has to identify the question to which the voices are addressed. And the relevant question in this case is who was President of Venezuela during the period 2019 to 2020, when his appointments of the members of the Guaidó Board were purportedly made and purportedly quashed by the STJ. And the position immediately on the day before the effective date of Her Majesty's government, or His Majesty's government withdrawal of recognition, is no more relevant than the position the day after. We're not concerned at all on these facts with the position in any part of 2023. We're looking back to the position in 2019 and 2020. And the recognition of interim President Guaidó as at the date of the appointments tells the court that his acts are the acts of the Venezuelan state, which in principle therefore then engage the act of state doctrine prima facie. His continuing recognition by HMG when a pro-Maduro, if I can put it that way, STJ, later purports to quash those appointments, then tells the court that it would conflict with the one-voice doctrine to recognise those judgments.
I'm not sure you can say pro-Maduro, actually, because that was found against you.
My Lord, I'm sorry, that was a shorthand. What I meant to say was that supportive of the continuing position of Maduro. I didn't mean pro-Maduro in the sense of being non-independent. I meant that they considered that Maduro was the president.
Yes, I see.
Sorry, that wasn't intended to be a loaded remark. I was just trying to take it shortly. And we see an illustration of that sort of backward-looking exercise where the precise timing is important in civil air transport, which is at Authorities 5.
Yes, do you want us to look at that?
If you could look at it very quickly, the background to this was that 40 aircraft had been purportedly sold by the nationalist government of China to a US purchaser on the 12th of December 1949, which was at a time when the nationalists were being all but overrun by the communists and all but driven out of China by those rival forces. And the Hong Kong court needed to know whether His Majesty's government recognised the nationalist government at the time of that transfer. And so therefore they asked the very specific questions which appear at 85 of the bundle, which is 86 of the report. And one sees their second paragraph from the top: before reaching a decision in the present action, the Hong Kong court is required to know what government was recognised by His Majesty's government. And then one sees over the next 3 pages a series of successive questions being asked for clarification and then yet further clarification. And then on page 88 of the bundle, in the middle paragraph, Her Majesty's government in the United Kingdom is the sovereign government of Hong Kong, and the effect of the above replies is to establish that at any rate in the courts of Hong Kong and in the present appeal, the former nationalist government must be regarded as the sole de jure sovereign government of China up to midnight of January the 5th and 6th, 1950, and that the present communist government was not the de jure government until that time. And so that's dealing with a situation in which the position as it was has now been overtaken because there has been a recognition of the communist government, but what the court is interested to know on a backward-looking basis is who was recognised at the relevant time, because it's that government whose acts will be recognised. And one sees a very similar thing in the other case that we had cited.
Well, before we leave that, there's a passage at page 90 of the bundle, which says, for the purpose of judging the correctness of this first ground, the validity of the transaction must be judged as at the date when it was entered into and not in the light of subsequent events.
My Lord, I'm very grateful. Yes, I had that in my notes and I just skipped to the next. Yes, yes.
So, one of the ways you can know this, there can't be anything in this point, is that what if you had a perfectly ordinary transition of governments, for instance, pursuant to a free and fair election? Is it really to be said that the recognition of the previous regime, which had been, say, in place due to a free and fair election, all their acts cease to be recognised?
Mr. Lissac doesn't. That's not even Mr. Lissac's case. Mr. Lissac's case on the stay application was to accept what he referred to in his skeleton as the Gdynia principle, which was that the succession to a new government has no effect upon what has previously happened, unless and until there's a subsequent act of repudiation. And obviously, the departure of Mr. Guaidó leaves theoretically open the possibility of the Maduro Board establishing that there has been such act to restore Mr. Ortega, to nullify the appointments that I rely upon. That's the first instance. We're looking at the question of whether Mrs. Justice Cockerell was right by reference to the one voice doctrine to decline to recognise judgments which were issued at a time when the foreign judiciary took the opposite view to HMG as to who the legitimate president was.
It seems to me there were 2 strands to the argument against you. But first of all, it's said that you don't look at the date of the acts in question, but you look at a contemporary date. But not only that, you don't even look at it at the date the judge decided it.
No, it's the happenstance of when it comes on for appeal.
You look at it on an appeal. So even though we're deciding whether the judge was right when she decided it,
yes,
we have to look on the fiction that things were not as they were before the judge.
We see no logical principle to either strand of argument. The nearest I could get to understanding what Mr. Lissac meant about public policy was that the courts, Lord Lloyd Jones located this one voice principle as an element of public policy of the forum as to whether a foreign judgment should be recognised. And so obviously public policy can change, referred to in cases as being an unruly horse, and so I think Mr. Lisek may have in mind that the court looks at the public policy as it is now. But we're not talking about public policy in the abstract, in general terms. We're talking about this very specific element of policy which requires the judiciary, as a branch of the state, to adopt the same position at any relevant time in respect of who should be identified as the president or government. And when seen in those terms, just as the need for consistency, one could draw up a calendar identifying who on relevant dates was recognised, and then the court could look at that calendar and see who they should treat, as happened obviously in the case of civil air transport, as happened also in Gdynia, which is a case about the Polish government, not Peru, as Mr. Lisek suggested yesterday. That one has these backward-looking exercises in order to identify who is sovereign at a given time.
I suppose in theory, although not very likely, you could have a situation where the government were to come along now and say, well, although we said that Mr. Guaidó was the president in 2019, we've changed our minds about that, and we are now telling you that we recognise Mr. Maduro as having been president in 2019. In that case, the court would have to accept that,
Exactly.
I suppose. But that is still looking at what the position was in 2019.
Exactly.
And anyway, it's a rather far-fetched.
It's rather far-fetched. They can, and obviously we looked at this last time round in relation to Luther and Sega, about the potential for retroactive effect of recognition. And so you can have a rebel force, a revolutionary regime, which has established control but hasn't yet been recognised. And then when they are recognised, there's an element of retroactivity from the point at which they established their control. But that's not this case, because what's happened in this case, what's happened in civil air transport and Gdynia, is that it is clear from the terms in which HMG has expressed its recognition, the period of time during which that recognition was effective. And that binds the court, and there's no scope for any element of retroactivity or the revision of a status. Obviously, the fact of Luther and Sega was that the transfer of property wasn't originally treated as being a valid executive act, but then it was retroactively validated by the subsequent recognition of the Soviet government. But these are far removed from our facts.
Right. Is that your 5 minutes, or is that?
It's just an interesting point.
Yes.
Sorry.
You just say what you need to say, but all I really meant is does that?
No, that deals with my point. Yes, I'll move on to the next one, which is ground 3, natural justice. I've already dealt with the limited scope of the Maduro Board's permission, so I don't need to go back to that, other than to emphasise to the court that the Maduro Board skeleton at paragraph 42, which sets up the point, it is only paragraph 42C which corresponds to its permission. 42A, B, and D are wholly new points for which no permission has been sought. And then where the points are elaborated upon, it is only paragraphs 58 to 61 which deal with the domestic remedies point. And then the second preliminary point, before I get into the substance, is to step back and look at what the Maduro Board is really seeking to do here. To adapt Mr. Lisek's metaphor, it's not a steep incline, but a vertical and completely unassailable wall. It's common ground that the parties now sought to be bound in London were given no opportunity whatsoever in Caracas to argue for any different outcome. And that's the absolute paradigm case of an unfair trial. And I don't actually understand why the present case is said to be so very different to the Kafkaesque nightmare of a conviction without the accused having had any knowledge of the proceedings. And because although it's true that these were civil judgments rather than criminal, if one could go to the core 213, one sees there at 219 little Roman 4 one of the aspects of breach of natural justice that we relied upon, the breaches were compounded by the STJ's explicit encouragement to other state organs to take action against the Guaidó interests with a view to potential criminal liability. And that's common ground, that's not disputed. That was accepted to be what the STJ judgments did. And so, although not directly giving rise to criminal consequences, the expectation of the STJ was that other state organs would take action in relation to what had been found to be this supposed assault upon the rule of law. So we do say this is rather close to the Kafkaesque nightmare with which Mr. Lissac tries to draw a contrast. As to local remedies, the English law point, coming back to my sketch of the outline at the very outset of my submissions, is that Mr. Lissac needs to show that obiter dicta of Lord Justice Slade in Adams and Cape are wrong. And as I'll come on to show you, Lord Justice Slade thought that a party who had been denied even the primary opportunities of being heard and reasonable notification didn't have to pursue local remedies, that they were entitled upon enforcement to say, well, that was an unfair trial. I'm not going to dignify this unfair process by submitting to that foreign jurisdiction. I'll take my stand in the foreign court whenever anyone tries to enforce that unfair judgment against me. Slightly surprisingly, that's remained an open question since Adams and Cape. It's never been conclusively resolved. We would invite this court to grasp the nettle on this appeal and to decide that point. But I was surprised to hear Mr. Lissac say yesterday that it is trite, was his word, that the English court will have regard to local remedies, because the passage that he cites in his skeleton in support of that so-called principle has been cited entirely out of context. If we go to page 466 of the authorities bundle, this is tab 9, page 570 of the report. This is the bit that Mr. Lissac likes, is just between C and D. The court must, in our judgment, have regard to the availability of a remedy in deciding whether in the circumstances of any particular case substantial injustice has been proved. So that's the bit he seizes upon, but one sees from 2 pages prior, page 464.
Give me the bundle.
They're the same, my lord. It should be yes, it's PDF 464 as well. Then in D on that page, we therefore conclude that defendants have demonstrated, as Mr. Justice Scott held, that the method by which Judge Steger came to a decision as to the amount of the default judgment was by itself contrary to the requirement of substantial justice. If that fact is regarded as a sufficient and conclusive description of the proceedings, then that finding would serve to invalidate the judgment.
Sorry, where are you referring?
So I beg your pardon. This is page 464 in both the pagination,
Yes.
the bundle pagination, and
Yes.
the PDF.
But where?
568. It's at letter D.
Thank you.
Second main paragraph down. So there, it was being said that the trial would have been unfair, but as noted above, this is halfway down the paragraph, the Court of Appeal in Jacobson and Frachon was not required to consider whether, as Mr. Falconer submits, an opportunity to correct such a defect provided by the foreign system may either cause such a defect to cease to be in our law an effective breach of natural justice, or if there's any difference, cause the defendant to be unable to rely upon it for purposes of impeaching the judgment. And then so Mr. Playford submitted that the proof of this defect is a conclusive defence for the defendants. And then at the end of that paragraph, no authority establishes, he said, the requirement of use by a defendant of any local remedy. And then the critical passage, we accept that no authority binding this court has been cited to us establishing the proposition for which Mr. Falconer contended, it's at least clear that our law does not oblige a defendant who can show that a foreign judgment has been obtained by fraud to have used any available remedy in the foreign court with reference to that fraud if he's successfully to impeach that judgment in our courts. And he cites Avaloof and Jet Holdings, which we'll have a look at in a moment. And then he says, crucially, the position may well be the same in cases where there has been a breach of natural justice of the two primary kinds considered by Lord Justice Atkin in Jacobson, namely absence of notice of the proceedings or failure to afford the defendant an opportunity of substantially presenting his case. So the obiter dicta, the inclination of Lord Justice Slade, is completely against Mr. Lissac. Because what was being looked at in Adam and Kate was a situation of a less serious type of allegation of breach of substantial justice. It was that there hadn't been a judicial determination, and the question was whether or not the opportunity to challenge the quantification of damages relieved the claimant seeking to enforce the judgment of a finding of a breach of natural justice such that the judgment couldn't be recognised. And so that's the obiter.
Well, doesn't he go on to say, or in fact they go on to say, because it's a judgment of the court,
Yes.
that it's not the availability of a right in the foreign court is not wholly irrelevant, and it would be at the bottom, letter G, it would be anomalous if our courts were obliged wholly to disregard the existence of a perfectly good remedy. So it's at any rate a factor.
Well, no, with respect, no. Our reading of this is that when the Court of Appeal is there contemplating that being a factor, it's only in the context of Adams and Cape of one of the less serious types of breach of natural justice. Where one's in the territory of a failure to notify and the denial of a right to be heard, we say that Adams and Cape doesn't decide the point, but it is suggesting that there may well be no requirement and that it's not open to... And indeed, one sees that from Briggs, the summary, this is at 1207. This is page 1207 of the bundle, extract from Briggs, Civil Jurisdiction and Judgments. The final paragraph on the page. In Adams and Cape, the question arose whether if there was a procedure in the foreign court for correcting breaches of the requirements of natural justice, it was incumbent upon the defendant to avail himself of it. The court held that it was not, at least in cases where the breach was fundamental and had deprived the defendant of notice of or an opportunity to take part in the proceedings. But in the case of a procedural irregularity of a less fundamental kind, it may be that this objection may not be made to the English court. That was the distinction I was seeking.
It'd be a bit odd to have an absolute rule even in a serious breach case, wouldn't it? Suppose you had a case where the judge was just a bad apple in the system. He was actually biased,
yes,
and gave a decision in favour of one party. But if there had been an appeal, the appeal court in that jurisdiction would have been outraged to hear about that, and would have clearly set the decision aside. But would you then be able to say, well, the availability of that remedy is simply irrelevant?
Well, no,
doesn't it all depend on the facts?
The premise of that would have been that the allegation is not one of the breach of natural justice and the denial of a right to be heard. It's that there hasn't been a fair hearing by an impartial tribunal. Where the complaint is that procedurally one has been shut out entirely from the process, the proposition which we extract is that the victim of that procedural unfairness can either take whatever chances he has in the domestic court, for instance, by complaining about the absence of notice to an appeal court, and if it's a fair system, which is what my lord posits, of a court of appeal who would be outraged at the judge not having dealt with it fairly, then he may be content to do that. But the point is that that defendant who has not had that opportunity isn't required to pursue those remedies. He's entirely free to take that objection in the court of enforcement and say, I didn't know about this. And that's his choice. And then that again picks up on Briggs. Clearly, it will be difficult for a defendant to be sure how to proceed if he appears before the foreign court to complain about the procedural irregularity, he may, by his act of submission, confirm the international jurisdiction of the foreign court. And so we say this is entirely principled, and this is why, by analogy, Lord Justice Slade pointed to the situation of cases of fraud, where obviously those points can be taken in the foreign court. They can also be taken in the court of enforcement. And then just another authority, again obiter, but illuminating, Agbara, a decision of Jason Koppel, sitting as a deputy judge of High Court. This was a case about the registration under statute of a Nigerian judgment under a reciprocal regime, so it's not strictly an application of the common law rules, but they have an analogy because he, in our submission, rightly thought that it was relevant to consider the common law position when considering whether it was just and convenient for the purposes of the statute to register the judgment. And so one sees at page 717 of the bundle, paragraph 32, breach of natural justice is a well-established defence to the right to enforce a judgment. Cites examples. If it were established that a judgment obtained in similar circumstances in a jurisdiction whose judgments are not within a statutory enforcement regime would not be enforced under common law, then that must, in my judgment, be at least material to the exercise of the 9-1 discretion. And then just to note that in the third line he cited Adams and Cape in relation to the common law rule. And then at paragraph 41, moving on, he says that I don't consider that Shell's failure to pursue an appeal in accordance with Nigerian procedural rules should lessen to any significant extent the force in the analysis under section 9.1 of the Administration of Justice Act of the serious breach of natural justice which occurred on that date. First, there is authority that a party complaining of a breach of natural justice in the obtaining of a foreign judgment which is of the most serious kind is not required to demonstrate that it's exhausted remedies by way of appeal against that judgment in the jurisdiction in which it was obtained, in Adams, Slade, Lord Justice Statement, and then it's the passage that I've taken the court to. And then 42, it was not necessary for the Court of Appeal in Adams to reach a definitive conclusion on that point because the alleged breach of natural justice in that case was not of the most serious kind. The breach in the present case does fall into the most serious kind, but strictly the point raised in Adams does not rise for temptation here either, as I'm only considering whether it be just and convenient. Nevertheless, it does seem to me that there's a material analogy, and it goes on. And as to that analogy, Lord Justice Slade in Adams had cited Abaloof and Jet Holdings. Abaloof is in the bundle at tab 2, page 40. If I could just ask the court to read the headnote without me reading it out. And at 45, Lord Coleridge, Chief Justice, about 10 lines down, says that many authorities from the Duchess of Kingston case down to our own time have been cited during the argument, but not one of them throws a doubt on the broad proposition that where a judgment has been obtained by the fraud of a party to a suit in a foreign country, he cannot prevent the question of fraud being litigated in the courts of this country when he seeks to enforce a judgment so obtained. And then 2 pages further on, it's been suggested, as second paragraph, with the sidelining, it's been suggested also there ought to be some limitation as to the rule that the obligation arising on the judgment can be annulled by the defence that the foreign court has been misled and not mistaken if under any circumstances the fraud could have been brought under the notice of the foreign court. I don't think the general proposition, broad as it is to be subjected to any limitation of that kind, and I'm of opinion that the fraud of the person who has obtained the foreign judgment is nonetheless capable of being pleaded and proved as an answer to an action on the foreign judgment in a proceeding in this country. And there's statements to similar effect by Lord Justice Bagalay at page 48 about 8 lines down, starting if the judgments have been improperly obtained. And then Lord Justice Brett, in the final paragraph on the page at 53, I accept the whole doctrine without any limitation that whenever a foreign judgment has been obtained by the fraud of the party relying upon it, it cannot be maintained in the courts of this country, and further that nothing ought to persuade an English court to enforce a judgment against any one party which has been obtained by fraud. And obviously it's only an analogy, it's not because it's not dealing with the procedural unfairness, but the basic concept is that there is no requirement for the victim of either fraud or the most serious types of procedural injustice to pursue those domestic remedies. Jet Holdings is at tab 8. Another one of the cases cited by Lord Justice Slade, and that starts at 314. There, a Californian judgment had been obtained by threats of violence by the plaintiffs, and then the defendants had been denied the opportunity to access to the Californian court. And at 344, it's 323 of the bundle, I beg your pardon. of the report, and this is Lord Justice Staunton in the middle of the page at E, where the objection to enforcement is based on jurisdiction, that's Rule 43 of Dicey. It's to my mind plain that the foreign court's decision on its own jurisdiction is neither conclusive nor relevant. If the foreign court had no jurisdiction in the eyes of English law, any conclusion it may have reached as to its own jurisdiction is of no value. And to put it bluntly, if not vulgarly, the foreign court cannot haul itself up by its own bootstraps. Logically, the same reasoning must apply where enforcement is resisted on the grounds of fraud. If the rule is that a foreign judgment obtained by fraud is not enforceable, it cannot matter that in the view of the foreign court there was no fraud. And then 345C, 324 of the bundle, I've said that in the alternative, the defendant also relies upon Rule 46 in Dicey and Morris, and the Rule 46 is dealing with the situation of a breach of substantial justice. And then at E, once again, one would expect that the foreign court's views would logically be neither conclusive nor relevant as to the propriety of its own proceedings. If the English court considers that the foreign court didn't observe the rules of natural justice, for example, the rule Audi alteram partem or nemo judex in rex suam, why should it make any difference that the foreign court thought that it was observing the rules of natural justice? And that's obiter because it was decided on the fraud ground rather than the natural justice ground, but it's further obiter support for the Adams and Cape dicta that in relation to the two most serious primary kinds of requirements of natural justice, namely notification and the right to be heard, there is no requirement to pursue any domestic remedy. It's up to the election of the defendant to take those points either in the foreign court or the court of enforcement. And then in our skeleton, I won't go to it again, but we mentioned UCOS in this context, where there's a much quoted passage by Lord Justice Ricks addressing the responsibility of courts to observe principles of natural justice, to comply with due process and to uphold the rule of law. And that's not admittedly addressing our specific point, but there is not a hint in that passage that where a foreign court has failed to observe the most fundamental requirements of natural justice, then a judgment issued in those circumstances might nevertheless be enforced because a party in Mr. Lissak's position says, oh, well, there was some route of procedural complaint available to you which you didn't take. And Mr. Lissak can point to no example of such a judgment ever having been enforced, which comes back to my introductory point yesterday about him needing to go so far beyond any decided case. He cites in his skeleton a case called Bergeron and Marsh, which is a case about a bankruptcy decree having been made on the court's own motion. But if one looks at the case, which is at Authorities 3, page 56, one sees the absolutely critical point that after the order was made, the bankrupt was given notice and the opportunity to oppose the order, and did in fact instruct counsel to oppose it. And so the judge in England drew a comparison with an English-style ex parte order with liberty to apply, to vary or set it aside. There's nothing inherently unfair about that. What's egregiously unfair is judgments to be issued which are final and unappealable, which, as is now conceded, do not give rise to any procedural remedy. And so that was the English law analysis, the Adams and Cape point. Although this case is bristling with issues, any one of which would be fatal to Mr. Lissac, we would respectfully suggest that this is an appropriate case for the court to grasp the nettle and decide the Adams and Cape point about the availability of domestic remedies. The permission was given by Mrs. Justice Cockerell because this case gave rise to issues of wider importance, and we say the Adams and Cape point left hanging since that decision is quintessentially in that category. And obviously, if the court's with me on that domestic remedies are simply irrelevant, then that's the end of Mr. Lissac's appeal anyway.
Mr. Fuller, I'm not surprised you didn't find it because it's tucked away in a dissenting judgment. But I said something about this in a case called Muin Udin in the context of hunter abuse. Paragraph 78. What I said there was, whilst I accept the availability of a right of appeal may provide a full opportunity for a fair trial to an accused despite a flawed procedure at first instance, the existence of such a right cannot, in my view, cure a process as inherently unfair and unjust as that adopted by the foreign tribunal in that case, where the legitimacy of the conviction is seriously in doubt on any international standards of fairness.
Well, my lord, that sounds entirely consistent with my submission, that when one's in the territory of such serious types of abuse, it is simply not open to a party in Mr. Lissac's position to say that this could have been cured.
The reference to this is 2022 EWCA Civil 1073.
Well, I'm very grateful. And then the second component of this head was the Venezuelan law point. That's now fallen away with Mr. Lissac's concession, although not yet handed up in the document, but I understand that to be a clear and unequivocal concession that he is not seeking to challenge the judge's conclusions that there was, on the facts, no domestic remedy available to my clients. And then, but just very briefly, although I say that he has no permission to run them, the points that Mr. Lissac seeks to make outside his grounds, we say, are completely incoherent anyway. If I could look first at his skeleton. I'll just find the page reference. It's footnote 32. Page 20 of the skeleton. So buried in a footnote is the observation that speaking in the context...
I don't think this
sorry.
skeleton has page numbers.
Oh, so it might be... No, this might be added by my device. It's on whichever page...
Anyway, footnote 32. I've got
footnote 32.
Yep, page 117.
Yes.
Thank you.
And then footnote 32, speaking in the context of English procedure, the editors of De Smith posit notice in some form of hearing as a potential core minimum of process rights, but that doesn't seem correct as a general matter, given that applications are regularly heard on a without notice basis and with other protections. If we could look at what De Smith has to say on this point, that's at Authorities 36, page 1218. The very final line on that page, this is paragraph 7040, which is cited by Mr. Lissac. Procedural fairness is also a constantly evolving concept, in inverted commas. And then, however, although the extent of fair procedures required is context-based, it appears that there is a core minimum of process rights required involving notice and some form of hearing. And so even in the wider context of the judicial review of administrative action, the editors of this text are saying that there is a core minimum, to which Mr. Lissack says, well, that doesn't seem to be right, because one can have ex parte hearings. One can't have ex parte hearings which result in a final and unappealable judgment without the affected party ever having the benefit of a return date. And so insofar as it's even useful to consider universal principles of natural justice which apply across the board between judicial and administrative decision-making, the Maduro Board is simply wrong to say that notification and a right to be heard are optional requirements. But in any event, the domestic judicial review of administrative action has nothing to do anyway with the question of whether a foreign judgment is eligible for recognition. We don't need to go back to Adams and Cape, but that point's made very clear by Lord Justice Slade at page 566 C to F of the report. This is Authorities 9, page 462. He says it's just not helpful to have cases cited about administrative action because that is more fact-specific and variable. But even then, De Smith makes clear, and Mr. Lissack hasn't pointed you to any authority to suggest otherwise, there are minimum irreducible requirements. But that doesn't even help the court when it's considering the question of the recognition of a foreign judgment issued in circumstances where the parties sought to be bound in London had no opportunity to participate in Caracas. And there is also now an entirely new factual case sought to be advanced that the nature of the judgments was an emergency and justifiable response to the level of perceived threat to the authority of the Maduro government. That wasn't Mr. Lissack's factual case at trial, hence why he can point to no evidence. There's nothing referenced in the skeletons which set out that narrative. And they aren't explanations of the STJ's conduct which appear on the face of the judgments to explain and justify why the STJ thought it was appropriate to arrive at these decisions behind closed doors. And indeed, it would have caused Mr. Lissack the most immense problems at the trial to have advanced this case about it being the Maduro regime's response, because that would have played straight into our argument that the STJ was operating as a puppet of the Maduro regime. But in any event, the perceived consequence, the matters of importance, the constitutional crisis, are not a reason to dispense with the requirements of natural justice, they are a reason to observe them. And even in a domestic context, one sees illustrations of that. You look, for instance, at the Miller case. The speed at which the English judicial system was mobilised to go straight up to the Supreme Court to consider the legality of prorogation. And that wasn't a decision that was reached behind closed doors. It was a decision reached after all interested parties and groups had had the opportunity to participate. And no doubt, when you have decisions which affect a lot of people, there needs to be appropriate case management to ensure that there isn't duplication and the whole thing becomes unworkable. But we don't suggest, Mr. Lissack was positing, that every single legislator needed to have been a party to decisions, but there needs to be someone there to put the contrary argument and defend their position. And that's why Mrs. Justice Cockerell said, by reference to Govella, the European case, that there's something of a difference between not everyone being before the court and absolutely no one. And so we say that Mr. Lissack's submissions about the constitutional importance and the urgency and drama of all of this count absolutely against him. It's precisely in those situations where the stakes are at their highest that the need to scrupulously observe the requirements of natural justice are most important. And there was a curious submission that there was an equivalence of exclusion in that no one had the opportunity to participate, implying that that made the procedure fairer. We simply don't understand that submission, particularly when it's the Maduro Board seeking to take advantage of these decisions which are adverse to our position. And then there was no basis either to say that in rem judgments are somehow exempt from the requirements of natural justice and the opportunity to be heard. The in rem procedure, at least in an English conception, is simply a different means by which parties are given the opportunity to come before the court and declare their interest in a ship or a cargo. It doesn't mean that anything takes place behind closed doors and without interested parties having the opportunity to be heard. It simply means that those parties who haven't participated may nevertheless be affected to the extent of their interest in the res, notwithstanding that they haven't participated. And so it's not licensed, not carte blanche for unfair procedures in any sense. And then just finally, a point made at the very end of Mr. Lissak's submission is that one can apparently, he says, see recited on the face of the STJ judgments the arguments that might have been made in opposition. We say that's an absolutely absurd argument just as a matter of principle. The right to natural justice and a fair trial is not the right to see in print the court's perception of the points that you might have made had you been there. But in any event, we simply don't understand how that point works on the fact. We can't see on the face of those STJ judgments any consideration of the countervailing arguments which members of the National Assembly, which Mr. Guaidó, which members of the Guaidó Board might have wished to raise. At a very minimum, they would have included the argument that the idea that the entire democratically elected legislature of Venezuela could be held in contempt and then paralysed from legislating was itself completely wrong as a matter of Venezuelan law. But that's the view that the STJ took. That was the basis upon which Mr. Maduro was seeking to silence the opposition-controlled National Assembly. And so we do say, most obviously by reason of the concession that was made at 9:35 this morning, but also for these other reasons, that the natural justice ground is absolutely unarguable. And that was certainly the view that the judge took, not only in the trial judgment, but also in relation to the permission to appeal, where she said the gap for the Maduro Board in establishing a real prospect was particularly wide, because they didn't seem to have a tenable case. And the only case being run was previously a domestic remedies one, which is wrong as a matter of law if the court accepts Adams and Cape reflects the law, and is abandoned now as a matter of fact anyway, and Mr. Lissak has no permission to run any other case. So I think I'm making good progress. That's all I had on that ground. Ground one then just remains is in rem. Before I get into this, can I just make a few points about the context in which it arises? We haven't needed to focus on issue one in the judgment of Mrs. Justice Cockerell because it's not under appeal. But it does provide some context to this part of the analysis, because the debate, as you may have picked up if you skimmed that section under issue one, was that Mr. Lissak was seeking the recognition of 5 other judgments of the STJ, which didn't directly quash the executive acts of Mr. Guaidó, but which Mr. Lissak said demonstrated by their reasoning that Mr. Guaidó's acts must have been unlawful and invalid as a matter of Venezuelan law. And understandably, given that was the way he put his argument, he labelled them implied quashing decisions, because the necessary implication of the reasoning of the judgment was that Mr. Guaidó's appointments could not stand. This was dealt with in the core, page 190, tab 7. It starts at page 133 under the heading, paragraph 133 under the heading, the Part 1 judgments. We don't need to go back to the table showing the detail. We can pick it up at 140 on page 195 of the bundle. submission was that in circumstances where sovereign power is shared amongst the legislative, executive and judicial branches of government, it cannot be assumed that the conduct of the executive should prevail over the position taken by the judiciary. It submitted no evident principal basis for limiting the court's recognition and consideration of the judiciary's decisions, themselves manifestations of sovereign power, to explicit declarations of nullity, as opposed to decisions that impliedly or unquestionably by their reasoning render an executive act a nullity so as to engage the limitation to act of state. So that was the submission. 142, Mrs. Justice Cockerell says, the point was put with great skill by Mr. Lissac for the Maduro Board, but it falters against the history of the case. In the Supreme Court, the battle lines were drawn thus. The Maduro Board contended that the foreign act of state doctrine had no application at all to executive acts which were unlawful under their own law. Hence, it was always necessary for an English court to look at what the foreign courts had decided. The Guaidó Board argued that since it was irrelevant whether a sovereign act was lawful or unlawful, anything a foreign court had to say about lawfulness was logically irrelevant also, subject only to the proviso as to public policy. And then the judge correctly summarises that the Supreme Court didn't adopt either course. Instead, it held that the ability to deploy a foreign judgment striking down the act ought not to be confined to a public policy inquiry, and that there was an exception to the foreign act of state doctrine for executive acts which had been quashed. The question was asked in those terms, and then there's the quote from Lord Lloyd-Jones. And then Mrs. Justice Cockerell held that the implicit quashing argument is therefore an attempt to reprise an argument which has been considered and rejected by the Supreme Court. The debate about where the line between the executive and the judiciary should be drawn is one which the Supreme Court has considered and reached its own clear conclusions. And so this is important in this context because the judgments of the STJ are relevant not because of what they say about Venezuelan law, but because of what they do to the executive act which is being quashed. And once the act has been quashed, then there is no longer an act to engage the act of state doctrine. And that's the logic of the Supreme Court's approach. On the one hand, accepting Lord Sumption's analysis from Belhage that the foreign act of state doctrine extends to foreign acts which are unlawful. So it's no answer to an act of state to say, well, that you had no power to do that. That's why we were able to rely upon the executive acts without the need for the legislative underpinnings of the transition statute. The Supreme Court held that we were right to say that the executive act could stand as acts of state, even if the transition statute was invalid and Mr. Guaidó lacked the powers which he claimed to have. So that's the starting point. And then by way of limitation or exception to the act of state principle, one has the possibility of those acts having been quashed by the foreign state's own judiciary. And it doesn't matter that they have been quashed because they are unlawful. The point is that they've been quashed. And the question then becomes, who in proceedings in London is affected by the quashing in Caracas of those acts? And that's where we get into the framework of recognition, the rules of in personam and in rem judgments. Because crucially, one is not interested to know, in this context, in terms of the operation of the act of state principle and this exception as newly formulated to the act of state principle, one's not interested in the question of whether or not there's a proper legal basis. Obviously, in a different case, in say, a private law case, which gave rise to no act of state considerations, this court would always be interested to know what the apex court, the constitutional court of the foreign state, had ruled about the constitutionality of either those particular acts or equivalent acts from which the English court could then reach its own conclusion as to legality. It could say, well, this is easy for me because, helpfully, the constitutional court has already decided, the very point at which I'm asked to decide in England. It said there is no valid transition statute, and therefore I can conclude that these purported acts must have been invalid, the contracts entered into fall away, whatever other private law consequences flow. When one's in the territory of active state, however, where illegality becomes irrelevant, the acts have their status by reference to their sovereign character rather than their domestic law legality. One's no longer interested to know what the Venezuelan legal analysis was. All one's interested to know is whether there's a quashing decision. And that's why Mrs. Justice Cockerell drew the line where she did, saying it's only quashing decisions which fall within the exception. And then crucially, in relation to those quashing decisions, one needs to find out whether or not there is a conventional English conflicts of laws framework to treat those quashing decisions as being binding, as giving rights to issue estoppels as against parties in London. Had they been parties to the Venezuelan action, obviously they would have been bound in personam. That's not relied upon, so Mr. Lissak's driven to present this in rem argument. But I thought it was useful to just set out the context and before we get there, because the starting point is that the framework of recognition of foreign judgments is subject to ordinary domestic rules of English private international law, which apply to the recognition of foreign judgments generally. And I emphasise that because those rules draw no distinction between types of court, levels of court, or types of person, natural or non-natural, who might be affected by the decisions of those foreign courts. And there was a brief exchange yesterday between Mr. Lissak and the bench about these being constitutional courts and the constitutional status of the BCV. But those are irrelevant facts as far as foreign judgments are concerned. There is no significance to these features under our rules of recognition of foreign judgments. And indeed, I didn't understand Mr. Lissak to be embracing the idea that these aspects of Venezuelan internal constitutional framework could somehow help define the boundaries for a recognition analysis in London. And so these are universal principles. Mr. Lissak needs to put himself within rules which apply to all types of judgment. And here, of course, there are no arrangements for mutual recognition as between the UK and Venezuela. So therefore, we are concerned solely with the common law position. Obviously, those common law rules distinguish between foreign judgments in personam and foreign judgments in rem. And the Maduro Board rightly concede that they cannot rely on the in personam rules. Had anyone been present in Venezuela before the STJ, then we might have had to have the argument in London as to whether it could be said that parties in London were somehow privies of the parties in Venezuela. We've been spared that debate because these were behind closed doors entirely, so there is simply no scope for any in personam operation. The narrow focus under ground one of the appeal is therefore the English common law rule of private international law governing the recognition of foreign judgments in rem. At the first place one obviously looks to find such a common law rule is Dicey, and then that's at 1227 of the bundle. You were shown this page yesterday, but slightly curiously in an appeal about judgments in rem, you weren't shown the rule. The rule is Rule 50. A court of a foreign country has jurisdiction to give a judgment in rem capable of enforcement or recognition in England if the subject matter of the proceedings wherein that judgment was given was immovable or movable property which was at the time of the proceedings situate in that country. And so that's the rule. What's now Rule 50 had been Rule 47 in the 15th edition, which was current at the time of Mrs. Justice Cockerell's judgment. When Patney was before the Privy Council, it was Rule 40, but it's always been in the same terms. And then one sees immediately from the text of the rule itself that it is expressed solely in terms of property, immovable or movable within the foreign jurisdiction. And the Maduro Board aren't within Rule 50 because the STJ judgments aren't decisions about property, but about the quashing of acts of appointment. And although it's right to say that the purpose of the appointments was to confer control over the BCV's property, in London and elsewhere outside Venezuela. That doesn't help the Maduro Board because, for that very reason, the property in question was outside Venezuela. And so what's entirely clear is that the Maduro Board are outside the language of Dicey Rule 50, to which the Maduro Board say in their skeleton, although it wasn't repeated yesterday in oral submissions, well, Dicey is just an expression of the editor's view, you need to look at the authorities. And then the first authority, footnoted, one sees Rule 50, footnote 428. The first authority cited is Castreek and Imrie, decision of the House of Lords. We see the continuing relevance of that case from the decision of this court, the Court of Appeal in Cosa, which is at paragraph 20, tab 25 of the authority. Tab 25, page 992 of the bundle. Cosa is a case from 2022, slightly less than 12 months ago. Paragraph 60, the leading authority on recognition of judgments in rem is the decision of the House of Lords in Castreek and Imrie. And then the Chancellor who gave the leading judgment explains that that concerned an English ship sold under a judgment of the French court whilst in port in France to settle a debt for necessaries. If the court could just read on to the bottom of page 61, bottom of paragraph 61. And the important point we derive from that, first and foremost, is that Castreek and Imrie is a case about property, a classic ship case. But also, the point emphasised by Mr. Scott in that case, which is that it was being treated as a recognition of judgment question, not a choice of law question, because the French courts had got the law wrong. But the point was that the judgment was binding on the parties before the English court because the French court had been exercising its sovereign authority over a ship within its territorial jurisdiction.
Just a note, at the end of 59, the Chancellor does recognise that it may extend beyond property. He refers to determinations of marital status and appointments of receivers and other office holders.
Yes, yes. That insolvency office holders. There's no support whatsoever for the idea of that being the office holder in the sense of a company.
Yeah.
And that's there's a limited scope for that type of appointment.
Yes. So to understand your point on that, would you say that if a foreign judgment to which the relevant people here are not parties, not privy, dealt with the appointment of a different sort of office holder, its relevance to the English court would be a sort of choice of law matter?
It would be irrelevant. It would be
it's relevant to determine what the foreign law is.
Oh, I see. If the English court were being asked to start afresh and consider the validity, but that's not recognition of judgments. That's applying a foreign law.
Yes.
Yes. Sorry, I understand the question. Yes. So
but equally here, just leaving the facts of this case to one side, it may well be you would expect it to be a matter of Venezuelan law on choice of law principles.
And we've always accepted that.
As to who the
we've always accepted that the question of the validity of appointments is a matter of Venezuelan law, insofar as Venezuelan law is relevant. The reason why Venezuelan law is irrelevant is not because there's another system of law which applies in terms of the validity of the appointments. It's because it's overtaken by the Act of State analysis, which says it doesn't matter because they're sovereign acts.
I see.
And that's why I set this up by putting this in the context of the act of state debate, because it can be extremely confusing to conceptualise this in different contexts outside of act of state, where the English court is extremely interested in the question of legality and validity. When that's been put to one side by the act of state analysis, and all one's interested in is whether or not a quashing decision of the foreign judiciary is binding in London upon parties who weren't parties in didn't have the opportunity to say anything in Caracas, then one's in the framework of recognition, and we say they can't put themselves within in personam, they accept that, and Dicey Rule 50 is confined to property. And the fact that a similar terminology about in rem has been used in other contexts, for instance, marital context, I'll come on to show the court that that's not an appropriate analogy. That's a dead end as far as any development of the law is concerned. But if we could just go to Castries, though, rather than just doing it through COSA, that's at tab 1 of the authorities, page 4. I've shown the court the facts via the summary in COSA, but the relevant bit that we just point to, and is quoted in our skeleton, appears at page 19 of the bundle, page 429 of the report. 6 lines down, in the middle of the second paragraph, we think the inquiry is first whether the subject matter was so situated as to be within the lawful control of the state under the authority of which the court sits. And then that's a point that's been made by reference to Story. And then back on the prior page, page 18 of the bundle, one sees in Story on the conflict, sorry, this is about 8 lines up from the bottom. In Story on the conflict of laws, it's said that the principle that the judgment is conclusive is applied to all proceedings in rem as to movable property within the jurisdiction of the court pronouncing the judgment. So the first step of the inquiry is the physical location of the property. And it's entirely easy to see why, because this all is about a framework of sovereignty and the recognition by the English court in terms of the framework of conflict rules, where the proper limits of the foreign state's sovereignty lie. And so far as persons and property within its jurisdiction, the courts have sovereign authority, the courts of that foreign state have authority over those persons and property. What the foreign courts cannot purport to do is to bind parties to judgments which they haven't submitted, in proceedings they haven't submitted to, and where they can't, or the party seeking to enforce the judgment can't point to any property having been within the foreign jurisdiction. And so that the framework, the proper boundaries of sovereignty is absolutely the structure of these rules, both as to in personam jurisdiction and also as to in rem jurisdiction. I don't think we need to go back to Dicey, but the court can take it from me that there are a series of other cases cited at footnote 428 in support of Rule 50, none of which say anything new or different. But at the very end of that footnote, there's a reference to the Foreign Judgments Reciprocal Enforcement Act 1933, section 4.2b. That's in the bundle at 1188. And the way, in the context of reciprocal enforcement under the 1933 Act, the rule of in rem recognition is expressed is, in the case of a judgment given in an action of which the subject matter was immovable property, or in an action in which the subject matter was immovable property, an action in rem in which the subject matter was movable property, if the property in question was at the time of the proceedings in the original court situate in the country of that court. And that's the principle governing whether or not the foreign court will be treated as having had jurisdiction. We are not operating under the 1933 Act, but its relevance appears later on in the bundle at 1246. This is another passage from Dicey 14:190. 4 lines from the bottom. The grounds of jurisdiction in the 1933 Act were deliberately framed so as to reproduce the rules of the common law as closely as possible. And strikingly, the Maduro Board say at paragraph 23 of their skeleton that the Dicey rule isn't legislation, which is true, but the Dicey rule, as expressed now in Rule 50, has tracked the language of primary legislation, which Parliament itself considered was, as at 1933, an accurate reflection of the common law position. And that doesn't exclude the possibility that Parliament was mistaken in 1933 about the true scope of the common law rule, as it then stood, or that the common law has since moved on. But the Maduro Board would need to make it by showing either a pre-1933 case which Parliament had overlooked, or a post-1933 case which had moved the law on. And they can't do either when Castrique and Imrie was the leading House of Lords authority both before and after 1933, and has been reaffirmed by this court in COSA within the last 12 months. So in short, the rule about in rem recognition is about property situate within the foreign jurisdiction. And to which the Maduro Board goes on to say that you find the law not in fact in Rule 50 after all, but in Patney and Salah, decisions of the Privy Council and the Court of Appeal, which aren't cases which are cited at footnote 428 of Dicey or 430, because they don't purport to say anything different. We look at Patney, which is at Authorities tab 13, page 521. This is the judgment of Lord Mance. One sees at paragraph 14, citing what was then the formulation of the Dicey Rule 40, which is in the same terms referring to property in the foreign country. And then if one goes on to 18, 522 of the bundle, their lordships note at the outset that Rule 41 in Dicey is dealing with the circumstances and extent to which an English court will treat a judgment in rem given in a foreign state as capable of enforcement in England, that is, as capable of enforcement or recognition in England as a judgment in rem. So there's no suggestion in Patney that somehow Dicey Rule then 40 isn't exhaustive or doesn't accurately state the rule. Paragraph 20, 2 paragraphs further on, cites Castrique and Imrie, which I've just shown the court. That's in the 3rd line, Dicey giving examples of cases which divided judges. And then at 21, for present purposes, a judgment in rem in the sense of Rule 40, i.e. a judgment in rem entitled to recognition in London according to conflicts rules, is thus a judgment by a court where the relevant property is situate, adjudicating on title or disposition as against the whole world and not merely as between parties or their privies in litigation before it. So an absolutely clear black and white reaffirmation of the proprietary character of this particular rule of recognition.
I'm looking at paragraph 169 in the Supreme Court, and just wondering whether what Lord Lloyd-Jones said had anything to do with this distinction between in rem and in personam. I mean, he talks about giving effect to a judicial decision whereby the courts of the foreign state concerned, acting within their proper constitutional sphere, have previously declared the executive acts to be unlawful and nullities. And he gives the example of a decision by the US Supreme Court declaring unconstitutional an executive act of the US President.
Yes.
And says, well, we in England ought to give effect to that decision of the Supreme Court.
Yes.
And that reasoning does not in any way depend upon either the Executive Act being concerned with property which is property which is located within the United States, or with whether the people concerned with that were parties to the American proceedings, so as to be bound in persona. I mean, he's simply not interested in that. He just says we wouldn't give effect to the President's Executive Act if the Supreme Court have declared it unconstitutional.
He certainly doesn't deal with the question of who was parties and who would be bound, but that he plainly will have anticipated that in that Supreme Court situation, where a presidential act is sought to be impugned by the US Supreme Court, that the US President himself or herself would have had the opportunity to participate and defend the validity of what they had done. And thereby, they would have been parties, the President would be parties, and those other individuals who sought to derive their authority through the President by virtue of an appointment or some other act would be treated in a conventional English law analysis as being privy to that judgment, because they have a community of interest with the President in defending their own status by the President's defence of the validity of his executive order, for instance. And so it's just unthinkable. I mean, plainly, Lord Lloyd-Jones wouldn't have envisaged a situation where the US Supreme Court was issuing judgments in which no one had participated in order to put the contrary case. And those parties who are before the court to put the contrary case are likely to be treated as privies, as though with the parties who have the same interest when it came to whether or not they're bound by the foreign decision.
Well, it might not be. The issue in the English proceedings might be between private parties, one of whom is relying on the Executive Act and the other isn't, and they were nothing to do with the litigation in the Supreme Court.
Well, they may have had nothing to do with it, but if their interest is equivalent to, and obviously we're only talking, because this is the point of emphasising how narrow this exception is, we're only ever talking about quashing exceptions. So someone who derives their ownership of property through some executive act of a foreign state, if that has been upheld or quashed by the foreign court, then the English court is likely will have regard to that on ordinary conflict and recognition basis. Here the question is whether or not when a foreign executive act has been quashed without anyone who is affected by that quashing having had the opportunity to be heard, it can bind anyone. And Lord Lloyd-Jones also envisaged that the recognition of such foreign judgments would operate within the rules of private international law, including the policy of the forum. He didn't suggest there was a special rule of recognition to allow for the quashing by a constitutional court. And indeed, it doesn't matter in this context whether or not it was a constitutional court. The quashing by a first instance court would equally engage the limitation of the Act of State doctrine. If there were a judicial review at first instance, I mean, just imagine that the Venezuelan court structure was similar to ours. If there were a case in the administrative court quashing what would otherwise have been an act of state which an English court couldn't question, and then that's quashed by the first instance court, then that quashing is binding upon the decision maker who would be expected to be party or at least treated as bound. It's binding also on anyone who purports to derive authority from that decision or that appointment or whatever it is that is being quashed. So that there is no need to develop some new rule, because this can all be accommodated with an entirely conventional in personam rules as to who is bound. And that was Mrs. Justice Cockerell's analysis, and that was her concern about the floodgates point also, is that where do you draw the line? Because it's not enough in this context for an English court just to say, well, the foreign court has declared what the law is, so I'll treat that law as effective and applicable as against the parties before me, because what we're concerned with is whether the parties in London are bound by an issue estoppel arising out of the decision made in the foreign court. That's the only possible analysis of it, and that's why we're in the territory of recognition of foreign judgments, and it has to be within that framework. And if it were a decision about Venezuelan property situated in Venezuela, if this had been a transfer of shares, if the BCV had shares and they were treated as being located within Venezuela, then that would be an in rem judgment. But that's not how the case can be put, because this wasn't a transfer of property. This was about rights of appointment over property overseas. And there's just no reason to fashion a rule which enables parties in Mr. Lissak's position to have recognised in London a decision about the status of appointments to which neither the appointer nor the appointees nor the entity over which those appointments were made have participated. And that's not a natural justice point, although it obviously shades into natural justice because the in rem rules don't exist in a vacuum. But it's a question of the gateway. How on earth does Mr. Lissak say that what's the rule that he relies upon? He can't rely upon Rule 50. And there's no basis to think that Lord Lloyd-Jones was seeking to create a new rule. On the contrary, he was making absolutely clear that it's the bog standard rules of English private international law which govern the question of whether a foreign judgment can be recognised in England. And that was the whole paradigm. That was the argument before the Supreme Court was that there was no need to dispense with the relevance of foreign quashing decisions, because there's already a framework of rules which determines whether or not the English court has to take account of that. So what the Supreme Court was doing was reconciling this apparent tension between the irrelevance of illegality in an act of state sense, and then the principles of the rule of law by which the English court has regard to the decisions of foreign courts. And the reconciliation of that tension was by saying, well, if the foreign court has quashed the Executive Act, and if the foreign judgment is eligible for recognition on ordinary principles of domestic international law, including the policy of the forum, including one voice, then we'll recognise it. But if a party seeking to rely upon that foreign decision can't put themselves within those rules, then the foreign judgment is irrelevant. So I'm a little bit troubled.
Not troubled at all.
And then Salah, which is the only case, Salah, as we understand it, is relied upon insofar as it endorses, as a matter of English law, the position in Patney, which was obviously a Privy Council case. And then, I don't need to go to it, but in para 48 of Salah, one sees there, in terms, the status or disposition of property, in rem, only in relation to property. And then we do, I'm afraid, have to go back to Dicey to look at the commentary. This is Authorities 37, 1227. First three lines. A judgment in rem is a judgment whereunder one, possession or property in a thing is adjudged to a person, or two, the sale of a thing is, and that's obviously thing in the technical legal sense of property, is decreed in satisfaction of a claim against the thing itself. And so that's what Rule 50 is dealing with. Rule 50 is not even purporting to deal with these other categories, but because Dicey makes perfectly clear the term is also used to describe adjudication as to status such as decree or dissolution of marriage and a judgment ordering property to be sold by way of administration in bankruptcy or on death. Judgments of these last two categories are outside the scope of the chapter. You haven't been shown any other chapter. Mr. Listak is not seeking to rely upon any other chapter. He's trying to rely upon this, 14109 and Rule 50. But it's entirely clear that Rule 50 and the commentary is dealing with property cases. And Mr. Lissak says at footnote 9 of his skeleton that matrimonial status judgments are an example of judgments in rem which aren't about property. And that's a surprising submission, given that Mrs. Justice Cockerell had referred specifically to this category of judgment at 186 of her judgment, which is at Core 7206. She says at 185, first of all, that it's true that the common law has not been completely closed to development. And then at 186, further, the previous common law treatment doesn't support any wider application of common law rules. The careful accretion of the types of cases which are recorded in rem status by these courts rather reinforces the need for caution. For example, the development reflected in Dicey 14109 at 3, and as we looked at yesterday, that 3 hasn't changed as between the two editions, was one in relation to the recognition of foreign divorce proceedings, which has since been encapsulated in legislation. Its use outside this specific area was roundly rejected in Rubin at 110. And then if we can go to Rubin at 110, which is at 6679 of the bundle, tab 17. First of all, setting it up at 109, at the top of the page, the Rubin respondents question whether the rules remain sound in the modern world. It's true that the common law rule was rejected in Canada at first in the context of interprovincial recognitions of judgments, and it goes on to describe the position in Canada with a looser test of eligibility for recognition. And then at 110, there is no support in England for such an approach except in the field of family law. It refers to indica and indica. And then 4 lines down, this rule, now superseded by the Family Law Act 1986, was in part devised to avoid limping marriages, i.e. cases where the parties were regarded as divorced in one country but regarded as married in another. It has never been adopted outside the family law sphere in the context of foreign judgments. So absolutely no support for the idea that prior common law decisions about matrimonial status, which were the common law's response to a specific pragmatic problem about the mobility of couples, that provides any support whatsoever for the idea that these judgments can be recognised in relation to appointments to a central bank. And then while in Rubin, if we can move on to 129, perhaps first just picking up at 127, outside the sphere of matrimonial proceedings, reciprocity has not played a part in the recognition and enforcement of foreign judgments. So here again, one sees that matrimonial cases are treated separately. But then the key part is 129, 3 lines, the first 3 lines, a change in the settled law with the recognition of enforcement of judgments, and in particular the formulation of a rule for the identification of those courts which are to be regarded as courts of competent jurisdiction, skipping the brackets, has all the hallmarks of legislation and is a matter for the legislature and not for judicial innovation. And I completely accept that this was made in the context of, decision made in the context of international cross-border insolvency, but the principle holds good because these are settled rules of common law recognition in reliance upon which parties, including commercial parties with international interests, arrange their affairs. You cannot have a position where there is some great uncertainty and all of a sudden a foreign court is able to make some pronouncement which has this unexpectedly binding effect in circumstances where that decision cannot be put within the orthodox framework of either in personam jurisdiction via physical presence or submission to the jurisdiction, and it's not a case in relation to property within the foreign jurisdiction. It's completely heretical because it doesn't respect the proper boundaries of the foreign court's sovereign authority, which is the framework for all of this. Mr. Lissac wants to say that the Venezuelan court can simply make a pronouncement, it can declare something erga omnes, and that binds anyone to whom that judgment can be said to apply. But when there's been no in personam submission to that foreign jurisdiction, when it's not a case about property within Venezuela, the fact that internally the Venezuelan courts are exercising jurisdiction and internally regarded as competent to decide these issues is irrelevant as far as the foreign recognition is concerned, the framework for recognition of foreign judgments. And one sees the dilemma, and this appears at 130. Furthermore, the introduction of judge-made law extending the recognition and enforcement of foreign judgment would be only to the detriment of United Kingdom businesses without any corresponding benefit. I accept the appellant's point that if recognition and enforcement was simply left to the discretion of the court based on a factor like sufficient connection, a person in England who might have connections with a foreign territory which were only arguably sufficient would have to actively defend foreign proceedings which could result in an in personam judgment against him. So there needs to be certainty in relation to these rules of recognition so that parties who might stand to be affected by foreign decisions can decide whether or not they need to participate. And obviously, when the foreign proceeding is concerning property, be it a ship or a cargo or an aircraft, which is within the foreign court's territorial jurisdiction, then parties with such an interest in that res know that unless they participate to set out their interest, then they're going to be bound by the outcome. But outside that exceptional circumstance for movable and immovable property within the territorial jurisdiction, then it's all based upon in personam jurisdiction. It's only parties who have submitted to the foreign courts who will be treated in England as being bound by their reasoning. And so Rubin is one decision of our highest court which stands in the way of the Maduro Board's analysis. The other is Carl Zeiss in the House of Lords. The judge dealt with this at 161 of her judgment, which is at Core 7204. We don't say it's directly binding because Mrs. Justice Cockerell accepted Mr. Lissak's submission that didn't have in mind an in rem submission. But the point we make about Carl Zeiss is that was a case extensively argued up to the House of Lords as to who had authority to represent a particular German entity. And that question had been decided by the West German Supreme Court. But it was held by a majority of the House of Lords that the solicitors who were saying that they could bring proceedings, had authority to bring proceedings in London, weren't bound by the West German judgment because they hadn't been parties to the West German judgment, and there was no privity in interest between the solicitors and those persons who were privy. And so we obviously say that the outcome of a case like Carl Zeiss would have been entirely different if Mr. Lissak were right, because that if the decision as to the status of a right of representation made by the West German court were to have these in rem effects, because the West German court was purporting to lay down the law, not expecting anyone to come to a different conclusion, then that would have answered the question before the English court in Carl Zeiss. And it shows how cautious one needs to be in terms of this development, because different points can be put, different arguments can be put. And it's highly problematic to have a situation where you can have parties bound in relation to their status, without being appointed. There's just no reason to fashion such a rule. In the private law context, if it were a question of the appointment of a director to the board, or there were two rival appointments by two competing shareholders, that, as I understand it, is a question of status and a question of appointment, which Mr. Lissak would say is within the rule. And provided that the court that declares the validity of appointment is the same court as the place of incorporation, then he would say that because the lex incorporationis governs that question, then that decision of the foreign court is binding on everyone, despite the fact that the rival appointee, who wants to say that, no, I'm the one that's been validly appointed, hasn't had the opportunity to participate or hasn't in fact participated hasn't submitted to the foreign court's jurisdiction. And it's entirely lawless. It's completely inconsistent with the framework of recognition of foreign judgments, which after all are recognised right or wrong. as one sees from Tastriq and Imri. The French court got the law wrong, but the English court still had to apply it because the ship had been within the French court's jurisdiction. And so the proposition that Mr. Lissac has to establish is that incorrect decisions of foreign courts give rise to issue estoppels in London as against parties who hadn't participated in cases which have nothing to do with foreign situate property. And although Mr. Lissac tries to rely upon the res judicata link, we say that's a completely muddled piece of thinking which confuses the question of applicable law with the question of recognition of foreign judgments. As I said a moment ago, that it has never been in dispute that Venezuelan law is the law which governs the appointments to the BCV. But the Supreme Court accepted our argument that even if they were unlawful, that wouldn't matter because of their status as acts of state, subject only to the potential recognition of quashing decisions. And then that's a point also made at COSA at 139 to 140. I don't think we need to go to it. That the contrast was there again being drawn between a choice of law analysis and a recognition of judgments analysis. That was a case where there were decisions of the Turkish court in relation to the particular appointment of a trustee, and so the Turkish rulings would be regarded as binding in Turkey. They were rulings about Turkish law. The question of appointment was a Turkish law question, but that wasn't the right paradigm that the English court had to consider, whether the Turkish judgment should be recognised here under English conflicts rules. And that wasn't a case where there was any problem about it being an in personam judgment, as I understand it, that the parties had participated and had their debate, not only at the Turkish First Instance Court, but also in the Court of Appeal. So there'd been full participation there. But the point we derive from that passage of COSA is just to draw the distinction of say this is not a choice of law point, this is a recognition of judgments question, and to have a foreign judgment recognised, i.e. to avoid the need to re-litigate the very thing that the foreign judgment decided. A party seeking to have such a judgment recognised needs to put themselves within an established rule. And Mr. Lissac can't, and he can't justify the expansion for the reasons that Mr. Justice Cockerell gave. So on the legal point, we say that the court ought to uphold the judge on this and to confirm the rule in Dicey, Rule 50, that's a rule about property. And there is no other rule, there's no other passage of Dicey which Mr. Lissac can put himself within, least of all matrimonial status cases. And so that's the problem for Mr. Lissac in the legal analysis on this ground, following my 3x2 structure. The further and freestanding problem for him is that the judge found, after consideration of the Venezuelan law evidence, that the STJ judgments did not, as a matter of Venezuelan law, correspond to what an English court will characterise as an in rem judgment for the purposes of the Dicey rule. And we find it impossible to see how the Maduro Board can persuade this court that that wasn't a finding of Venezuelan law which was open to the judge on the evidence. I'm afraid I haven't yet studied Mr. Lissac's table in relation to precisely what they now say in relation to these findings. At a glance, I think he was saying that he doesn't need to overturn the findings. If that was what he is saying, it's plainly wrong, because the judge needed to know whether or not Venezuelan courts can issue judgments with this in rem effect, whether or not they were called in rem judgments, and she held that they couldn't. And we say the judge was plainly justified in the conclusions that she reached. Mr. Arias, who was Mr. Lissac's expert, hadn't offered any coherent explanation as to why the decision of the Constitutional Chamber of the STJ should be equated to an in rem judgment. She pointed out at paragraph 169, which is at page 206 of the bundle, that he simply hadn't analysed the point, but merely assumed an equivalence. And then as to Professor Brewer-Carias, he wasn't even challenged by Mr. Lissac on his oral evidence, which the judge unsurprisingly therefore accepted, that the STJ judgments have only territorial effect. So the omnes is everyone in Venezuela rather than everyone in the world. Whereas the entire point of an in rem ruling is that when the ship, which is being subject to a judicial sale, sails out of those territorial waters, then the question of ownership of that ship has already been determined for the benefit of people in other sovereign territories. And so the worldwide nature of rulings as to movable property is absolutely inherent in the principle of recognition of in rem judgments. Operates slightly differently in relation to immovable property because that's not going anywhere. But in terms of ships and cargo and aircraft and these illustrations of in rem decisions, it's the very essence of it that they have worldwide effect. And as one sees from cases like Castrique and Imri, and Professor Carias was clear that that's not what the Venezuelan Supreme Tribunal was purporting to do. It's just saying what Venezuelan law is with territorial effect. And that territorial scope is not surprising at all, given the nature of the Constitutional Chamber's power to issue decisions which bind other Venezuelan courts hearing other disputes. It's common ground that the usual rule in Venezuela's civil law system, which the court here will no doubt be somewhat familiar, is that judgments of those courts don't create binding precedent in the same way as our common law system, but by way of specific constitutional and statutory exception to that general rule, the rulings of the Constitutional Chamber operate differently. An interpretation of the Constitution itself, or the identification of some other constitutional norm or principle, takes effect as a direct source of law. This was explained in Mr. Arias's own report. I don't think we need to look at it, but the reference is supplemental tab 13, 271 to 274, setting out this principle that clarification of an interpretation or the statement of a constitutional norm is a source of law. And then Mr. Arias accepted in my cross-examination of him that first instance courts can never give such binding rulings. This is unique to the Constitutional Chamber of the STJ. And again, we don't need to look that up, but it's supplemental tab 8, 135 in the mini pages, 37, line 23. And what that all shows, we say, is that the erga omnes concept under Venezuelan law has nothing at all in common with the decision of a foreign court doing something which is functionally equivalent to our Admiralty Court giving an in rem judgment about a ship. A much closer analogy would be the decision of our own Supreme Court authoritatively declaring the content of English law. That declaration by the UK Supreme Court as to what the principle of law is or how a statute should be interpreted, that takes effect generally. It has general effects, which is the Venezuelan erga omnes concept, but that's not, unless the Supreme Court is actually deciding an in rem case, it's not an in rem judgment. It's simply a question of the court with the sovereign power to do so, making a ruling which has general effects because other parties and other courts within the English system are bound by that finding, have to follow that finding. And so the erga omnes concept is a matter of precedent and constitutional clarification. It's got nothing at all in common with the power of an English court to give an in rem judgment. And again, we won't go back to it, but in that same passage of Castrique and Imri, the first test posited by Mr. Justice Blackburn was, first of all, is the property situated in the foreign sovereign territory, so that under the proper jurisdiction of the foreign court. And then the second question is whether the sovereign courts of that state have been imbued with the power to issue in rem judgments. And only if that second requirement is also fulfilled will an English court accord in rem status. And the Venezuelan proceedings here are much further removed from an English in rem proceeding than the Dutch proceedings were in airfoil, in which Mr. Justice Gross held that those Dutch proceedings could not be characterised as in rem because Dutch law had no such concept. And the Dutch ruling was erga omnes in terms. It's clear from the judgment recognised by Mrs. Justice Cockerell. It was expressed as being erga omnes. The experts were agreed about that. But it wasn't in rem because for conceptual reasons of Dutch law, that's not how Dutch law analysed it. And so we adopt the judge's summary of airfoil and the assistance it provides by way of analogy. She dealt with this at 166 to 173 of her judgment, which is at Core 7, 202 to 203. And there's then the further problem here with the nature of the proceeding itself. The very essence of an in rem proceeding is that by serving process on a ship, those who have an interest in the ship or its cargo, so at least deemed to have the opportunity to come forward and assert their interests without the need for all such persons to be separately served. And if we could just pick up just the summary of this in Dicey again, which is at 1223 of the bundle. We've previously been looking at chapter 14. This is chapter 13, jurisdiction in admiralty claims in rem, dealing with rule 44. The High Court has jurisdiction to entertain an admiralty claim in rem if the process is served on the res in England. And then introduction, the only claim in rem which exists in English law is an admiralty claim brought in the QBD of the High Court, now the KBD. The res is normally a ship, though, as will be seen below, it can sometimes be something else. And we'll look at that in a moment. The precise nature of a claim in rem has been a matter of controversy, but it may be distinguished from a claim in personam on the basis of two characteristics. First, if the judgment is solely in rem, it may be enforced only against the res. Consequently, it doesn't affect any entity which doesn't have an interest in the res. And if it does have such an interest, affect it only to the extent of that interest. So there again is an absolutely fundamental distinction between something having universal erga omnes effects and in rem effects. Because yes, it can affect non-parties to the proceedings, but only to the extent of their interest. And then going on, secondly, it's binding to the extent of his interest in the res on any entity which has such an interest, even if it wasn't served with process or otherwise informed of the proceedings, and even if it took no part in the proceedings. So the failure to take part is obviously an important characteristic, or the binding effect notwithstanding the failure to take part is an important characteristic, but only because service on the res is treated as sufficient for anyone with an interest in the res to have the opportunity to come forward. And it's obviously right, therefore, that an English court should not confer in rem status on a judgment unless it's clearly established that the foreign procedure and the nature of the foreign judgment emerging from that procedure operates the same way. And we say this chimes with Lord Reed's observations in Carl Zeiss about the need for caution in giving issue estoppel effects to any foreign judgment where the foreign court's procedures may be different to our own. And just to pick up the point about what else can be a res, this is over the page at 1226. The res against which admiralty claims in rem can be brought are as follows: ships, cargo, or in or landed from a ship and still identifiable as cargo, freight, aircraft and their cargo, and the process of sale of ships, cargo, or aircraft. So this has got absolutely nothing to do, this concept of an in rem judgment has got absolutely nothing to do with these wider categories in which perhaps rather loosely and inaccurately the term in rem has been used to describe the fact that there are some effects which go beyond the immediate parties to a decision. An in rem judgment, properly so called, for the purposes of Dicey Rule 50, is confined to movable or immovable property within the foreign jurisdiction. And then my final point, I think I'm then done. There is now a point taken that the release of a new edition of Dicey has made a crucial difference to the analysis. There's nothing in this point at all. The court will have seen from the judgment that Mrs. Justice Cockerell was doubtful that the editors had correctly summarised the effect of airfoil in the 15th edition, insofar as it did purport to say, or it did appear to say, that a judgment of the foreign court needs to declare itself and use the language of in rem in order to attract in rem effects in England. And she, having looked at airfoil, didn't think that's what Mr. Justice Gross was saying, so she followed the approach that it's not about language, it's about its intended effect. And applying airfoil by analogy, in which there had also been this dichotomy between erga omnes and in rem, she held that these judgments of the STJ didn't purport to be take effect as in rem judgments. Didn't matter what they were called, and it's not a submission that we were making either. If we could just look very quickly at the supplemental bundle, tab 9. Page 173. At the bottom right-hand corner, there was been a slight misunderstanding, and I said, forgive me, I was trying to cover off that point by saying we don't stand on ceremony.
Sorry, pages differ on the electronic.
Oh, I see. It's page 176 in the PDF, which should have 173 on the printed page. It's 116 of the mini pagination. Forgive me, I was trying to cover off that point by saying we don't stand on ceremony so far as the language is concerned, and it doesn't need to say this is an in rem judgment. And in fact, the more recent case, Warden Saville, supports that as well, because there the Chancellor says that one of the factors in why that shouldn't have been characterised as a judgment in rem is you would have expected Mr. Justice Butcher to have said so if that had been the intended effect. So we made it entirely clear that we weren't in any way making a submission that a judgment needs to call itself in rem. It's nothing to do with terminology, it's about its intended effect. And all these STJ judgments were intending to do was to declare the effect of Venezuelan law, which was what the Constitutional Chamber is entitled to do, acting in that sense within its sphere of competence. But that tells you nothing about whether or not those judgments are eligible for recognition within the orthodox framework of English private international law. And since they weren't about property, since that's the extent of Dicey Rule 50, Mr. Lissac cannot justify any principled expansion of those rules, then he fails. So, my lords, my lady, that was the conclusion of my submissions, unless there are any matters I can assist on.
Thank you very much. Yes, Mr. Lissac.
Rising to the last volley of failure, may I just explain how I've minded, subject to my lady and my lord's better view, to respond. First of all, I'll deal with the two tables that we prepared overnight and hand those into the court. They require little explanation, but I shall provide, I hope, sufficient very briefly. Secondly, I'll deal with the concession point, which my friend says ends the appeal. He's wrong, and I'll explain why. Thirdly, I will then turn to the matters we wish to make in reply, and there are 4 of them. Yes. I don't think I'll finish it for 1 o'clock. I might, but I'll do my best to do so, but without doing an injustice to the arguments.
No, that's fine. Thank
you very much. Can I start, please, by inviting the court to be given the 2 tables? Sorry, can I just check what I've been handed? Hang on a second.
you.
The table on top is a 6-page document in landscape that is a direct response to the submission made yesterday by my learned friend, to the effect that we had, and it's for the reference, it's transcript, page 74, lines 18 to 24. My learned friend said, in relation to every single point on which the two experts differed, she, that's to say Mrs. Justice Cockrell, preferred the evidence of Professor Brewer-Carrias in each case, always being careful to identify, even if relatively briefly, her reasons for doing so. I will not go to all of those passages, but the references are 155, 169, 176, 210, 227, 230 and 233. And we say, and the Maduro Board simply has not sought to explain in respect of any of its 3 grounds of appeal why this court should feel it is in a position to overturn the judge's findings and to make new and apposite findings about the content of Venezuelan law. We respectfully disagree. We have prepared this very short document for your consideration, and I hope it will prove helpful and reduce the scope of oral submissions.
Right.
At the back of the little clip that the court has been given is a 3-page note, which is the reduced synthesis of the severability analysis that was before the trial judge. What we have done is to pare back to just 2 STJ judgments to further reduce the burden on the court. And the note is our best effort as a neutral endeavour to identify what we say is and should be split. I should explain that the essential strand of reasoning that we say could be and should be severed is that regardless of who was president, the National Assembly was held by the STJ to have been in contempt continuously since 2015. And that was sufficient reason for the STJ to reach its conclusions that it did on the appointment of the Guaidó Board and regardless of its view of Mr. Guaido's status. This is an independent line of reasoning that predates and is separate from the status of Mr. Guaidó and does not start from the premise that Mr. Guaidó was not the president. The dispute, as I say, about whether the National Assembly was in contempt and what it had to do to purge that contempt, which is a long and complicated story I do not propose to trouble you with, is agreed, I think, on all sides to predate any claim made by Mr. Guaidó to be interim president. Again, we hope this very short synopsis will be of assistance to the court. May I turn now, please, to the concession, if I can call it that, which my learned friend has addressed you on earlier this morning in his submissions. It is a reference to page 4 of the first table. And you will recall that my learned friend submitted it at the end of the appeal. With the greatest of respect, my learned friend, he somewhat overreaches himself. And the third and the fourth column on page 4, and relating to judgment 227 to 230, paragraphs 227 to 230, we state the Maduro Board does not dispute these passages. In the premises, there is nothing in the passage referred to by the Guaidó Board which the Maduro Board needs to overturn. Now, of that concession, learned friend seeks to suggest that we are now going to lose because we have given away the ground upon which natural justice appeal is based, and that in so doing, we have shot ourselves plainly in the foot. That's, with respect to him, not correct. May I show you 3 documents, all in the core bundle, as to why he's wrong? Could I start, please, by, in the core bundle, inviting you to look at the grounds of appeal which is at provided one page 17 at the foot of that page. As you will see, and as you have already seen, in paragraph 4, we set out the generality of our complaint about natural justice and judgment issue 4A. It is respectfully submitted that in 239 of the judgment, learned Judge Erdin Law, in deciding the STJ judgments should not be recognised because they involved 1, a serious clear breach of natural and substantive justice, and 2, a denial of a fair trial under Article 6 of the ECHR. That is a freestanding basis to our appeal from what follows in paragraph 5. Paragraph 5, as to this, it is respectfully submitted that learned Judge Erdin Law, in fact, and ought to have found that domestic remedies were available as a matter of law and applied the doctrine in Adams and Cape. That in these circumstances there was no denial, alternatively no flagrant denial of the right to a fair trial under Article 6, the ECHR. We respectfully submit paragraphs 4 and 5 are divisible, and they are different, and I'll show you why. And we've been saying this for some considerable time in this case. Could I take you, please, to the judgment of Mrs. Justice Cockrell, Core Bundle tab 7, page 218, paragraph 239. In paragraph 239, Her Ladyship said this: accordingly, I conclude that if, contrary to my previous conclusions, the STJ judgments did fall to be recognised and did not offend against the one voice principle, the failings in natural justice in each case are serious, clear breaches of natural and substantial justice and a denial of a fair trial under Article 6 of the ECHR, in respect of which the label flagrant is appropriate and would render it inappropriate to recognise them. That was the judgment reached on the point which we specify in paragraph 4 of our grounds of appeal. And then for the detail, so far as this appeal is concerned, could I please invite you to kindly look at tab 2 in the core bundle, which is our skeleton argument of last October, page 114 in the bundle. And you'll see on 114, and I certainly shan't read it out because it's not helpful to you, paragraph 42, we identify by reference to paragraph 239 the specific complaints that we make, breaking down the generality of ground 4. And those are the same 4 arguments which I addressed you on previously. And it's at C, we have the failure to take into account availability of local remedies. So you are left with A, B, and D. May I please now turn to our 4 points in reply. The first deal will, so that my lords, my lady may know where I'm seeking to go, subject to an invitation to take a different path. Firstly, to deal with the new point on one voice. Secondly, to deal with one voice and act of state, picking up a point which I reflected on having read the transcript overnight, which fell from my Lord Justice Mayles during the course of submissions yesterday, and Milone has touched upon slightly in his submissions. Thirdly, severability, and an exchange between my Lord Justice Mayles again and my learned friend yesterday. Fourthly, in rem. And then I'm done. So, starting with the first point, the new point on one voice. As I hope I made clear in my original submissions, and there's been a trail of it in the unsuccessful application that we made, our respectful submission was that the ground is moot. And it's moot by reason of events that have overtaken us all. The public policy requires that there is a coherence between the position of the government and the courts. and that they should speak with one voice. That voice is first given air by what the government says. And the government said, as my lords pointed out to me in the course of our earlier submissions, rightly, if I may say so, between the 4th of February 2019 and the 31st of January 2023, that Mr. Guaidó was to be recognised as the interim president. But we adhere to our submission, not tediously, I hope, but firmly with respect, that what matters now is the government's now position and why it is to ensure that this court speaks with one voice with the government. What a previous UK government might have said, or what the present government have said some months or years ago, doesn't matter on this point. Everything has changed. Firstly, the Venezuelan courts invalidated the acts of Mr. Guaidó, as we know. Secondly, the position in Venezuela on the ground changed completely after the 22nd of December last year. Thirdly, the British government now has aligned itself with the position that exists to the extent of there being no interim president, no special attorney general, whether Mr. Guaidó or his appointees or somebody else. The former position has been abolished, the latter position has been abolished, and the UK government has now moved its position to reflect the reality. And so if one was asking oneself, what is the one voice to be heard today, it would, with respect to my lady and my lords, be that no one is recognised as president. Now, I'm not seeking to shoehorn into this reply a reprise of our application that found no favour with the court. What I am saying is that when one is looking at this first attack upon the one voice doctrine issue, it is right to recognise that what the English courts should be doing, in our respectful submission, is this. It should follow the government. And if the government's position is unplain, it should follow principle and authority. But whichever it does, and we now have a sequence set by which this appeal is to proceed to its conclusion first, whichever route is taken to this point, we respectfully submit that this court should consider the position as it actually is, not the position as it was. Because if one does it the other way around, you have a position in which the Venezuelan opposition have got rid of their interim president and special attorney general. The UK government recognised that reality. So there is, as it were, harmony. But the court will be proceeding on a different basis. Now, that's how I put that point. May I now please move to the second point of the four, which is one voice and act of state. Yesterday, my Lord Justice Mayles raised with me, and forgive my perhaps inadequate paraphrase of the point, we'll look at the transcript, whether the true contrast impinged on the prior holding that the Guaidó decrees are acts of state, the validity of which cannot be challenged in the English court. My Lord said, is not the contrast not between, on the one hand, the time when the English court is considering whether to recognise the judgment and the time when the judgment is given, but rather between the time when the English court is deciding whether to recognise the judgment and the time when the act which is said to be an act of state is committed. My Lord very graciously invited me to disagree with you, which I do with respect. we put it this way: we submit that the public policy point which is in play is entirely separate from act of state. The UK Supreme Court said that an act of state may not be recognised or enforced in England if the judiciary in the place said it is illegal in a judgment that should be afforded recognition. That was the point of departure for the remitted issue. But the question is, as I've just been saying, what is the position as it exists now? If we succeed in this appeal, and if the judgments are afforded recognition, then the impact on the act of state in this case will be consequential and indirect. So the measure that my Lord put to me as being the true issue is not the correct analogue for determining the issues that we are engaged on here. I say consequential and indirect because the prior issue is one of recognition. And after the recognition issue is decided, if it is decided in our favour, one moves to consider its impact. Thus, the exception to the act of state rule, much debated before my lords in the Court of Appeal in this case last time in September 2020, and again then in the Supreme Court thereafter, and now for a third time revisited in the appellate court at the highest level. The exception will be triggered, but that will not be because the court would be overruling or reversing the effect of the government's prior recognition, but rather by giving effect with one voice to the government's own reversal of its position. And in those circumstances, the effect on the act of state position would be entirely principled and in accordance with settled law. Whatever may be the thought or the reflection of the possibility that the act of state position will move cannot, in and of itself, dictate the answer to the prior issue of whether the one voice doctrine prevents recognition of the judgment or not. What we submit is entirely in keeping, with the greatest respect, with the Supreme Court's approach captured in the final subparagraph of the judgment. May I just respectfully remind you of how it is put? It's, as we know very well, authorities, tab 23. It's the last page of the report, and it's paragraph 181, subparagraph 3. However, in agreement with the Court of Appeal, I consider that to the extent that the Maduro Board may rely on judgments of the STJ, to which recognition or effect should be given by courts in this jurisdiction, in accordance with domestic rules of private international law and the public policy of the Forum, the rules identified in para 2A and B above would not be engaged. It is therefore necessary for the proceedings to be remitted to the Commercial Court for it to consider whether the judgments of the STJ should be recognised or given effect in this jurisdiction. Thus, the Supreme Court mandated a two-step approach. Step 1, may the Maduro Board rely on judgments of the STJ to which recognition or effect should be given by courts in this jurisdiction, in accordance with domestic rules of private international law and the public policy of the Forum. Step 2, if yes, and consequentially, the Act of State rules identified in paragraphs 2 and B would not be engaged. And that is how the sequence works in our respectful submission. But the one voice doctrine attaches to step 1 and not to step 2. Move to my next point, severability. Yesterday, my Lord Justice Mayles, put to my learned friend, and again I paraphrase, if there are two separate and distinct reasons for a conclusion in a judgment, would the court have to refuse recognition? It's pages 76 and 77 of yesterday's transcript.
Sorry, just to, I for one, have not received
Yeah.
the transcript
Oh.
from yesterday.
Well, I'm so sorry. I had no way of knowing that, obviously.
Yes.
Well, may
So
I?
if arrangements could be made.
Well, I'm so sorry, my
Yes,
lady. I
Yeah.
do beg your pardon. I'm so sorry the court's been inconvenienced like this.
They usually come electronically overnight, but for whatever reason they haven't reached us as yet. But you carry on, because you're telling us what the transcripts say,
yes.
and we will be confident that we will get them
Yes,
shortly.
and I'm reading from them, so I'm confident I'm not misleading.
Yes, quite.
Assuming I read accurately. So may I just say this is the only other reference to the transcript, if that's any comfort. So the way my lord put the matter to my learned friend was this. Suppose the foreign court had said there are two independent reasons for why the appointment of the Guaidó Board is unlawful. One is that they were made by Mr. Guaidó, who is not the president, because Mr. Maduro is, and the other is something else. Yes, says Mr. Fulton. Your Lordship continued, if it is actually spelled out that they are independent, is the English court still bound not to recognise that judgment? Answer from my learned friend, we say yes. We respectfully submit that this must be wrong, and that his argument doesn't withstand proper scrutiny. We invite this court to hold fast to the approach taken by the Supreme Court in paragraph 70, which we looked at extensively yesterday, but for your reference is pages 9... Sorry?
It's 170.
170, so thank you. 938 to 939 in tab 23 in the authorities. From that we divine, as you know, the correct approach is to start with the reasoning in the judgment which leads to the decisions, and then ask whether the conclusion depends on its impermissible view. If the answer is no, it is not dependent, then the conclusion passes the test. It should be afforded recognition or given effect in this jurisdiction. And my fourth and last point in reply, and I will finish by 1 o'clock, concerns my learned friend's submissions on in rem, and I make 3 disparate points. The first point I respectfully make is this. My learned friend argues for a restrictive and retrenched approach to the definition of the contours and boundaries of the in rem doctrine. He says, pointing at the new edition of Dicey, that Rule 50 is about property. He fastens on the phrase on page 1227 of tab 37 about the scope, where the editors state that the second and the third and fourth categories are out with the scope of this chapter. It's worth telling, my lady, my lords, that the same identical language appears in the prior edition of Dicey, and that is, for your reference, tab 31, page 1191. But it's a hollow point my learned friend makes, because those cross-references, when one pursues them, as I'm sure he has and knows, are firstly to the chapter on matrimonial law, and secondly to the chapter on bankruptcy. Then the learned friend takes you to tab 37, page 1223, and shows you a prior rule in Dicey. But as you will have noticed, that is a chapter concerned with admiralty. So as regards matrimonial law, bankruptcy and admiralty, we have some referencing, which is, I'm sure, of assistance. But he says, and that is that. His submission doesn't want for boldness, because we respectfully submit that he is wrong, and he's wrong for these reasons. Status is already an established category in rem labelling. And we rely upon 4 sources for that proposition: Patney, Saleh, Dicey 15, and Dicey 16. When my Lord
Sorry,
Justice...
do you mean the 15th and 16th editions?
Yes, I do. Yes, I do. So sorry. Yes. Shorthand from my
Not
own
rules.
typing. Yes, thank you. Thank you, my lady. When my Lord Justice Mayles put to my learned friend the passage from paragraph 169 in the Supreme Court's judgment, Lord Jones's judgment, about the United States President, my learned friend's answer was voluble and lengthy, but it didn't actually answer the point. It's perfectly obvious in our respectful submission that the lay behind my Lord's putting the point is right, and the learned friend had no real answer to it. The 2 other points that he makes that I think I should just deal with very briefly concern 2 authorities. Firstly, Koza, and secondly, Carl Zeiss, and I shall take them each shortly. Koza, which, to remind you with respect, is in the authorities bundle at tab 25, page 943, was relied upon by my learned friends at paragraph 7 of their skeleton, or bundle tab 3, page 128. And they asserted then and asserted today that the Court of Appeal judgment in that case contradicts the Maduro Board's argument, if we need it, for a modest expansion of the situations in which a foreign judgment may be classified as in rem, to include foreign judgments as to corporate status, such as the appointment of company boards. My lady, my lords, for 3 reasons we submit this proposition goes too far. Koza is authority for nothing of the sort. And we say that for 3 reasons. First, and most importantly, the legal point at issue in Koza was different to the legal points at issue here. Secondly, Koza is not binding in any event, in that the relevant parts my learned friend has relied upon were obiter. The appeal failed for 2 other grounds summarised in the report at paragraph 146, which is page 1013 in the bundle. And thirdly, Koza came to the Court of Appeals a case concerning an interlocutory jurisdiction challenge. And we respectfully submit that would neither be the time nor the place for determining any complicated substantive issues of the sort with which this court is now exceedingly well placed to grapple. And so the authority, which it does not actually serve the purposes for which my learned friend contended it might. The other case he made reference to is Carl Zeiss, and this is the last point in our reply, subject to anything you would have me deal with. The Guaidó Board previously, and again now, float the suggestion that because this is not an in personam judgment, there is no identity of parties in this instance asserting. The consequence of this is that an issue of estoppel cannot arise, and by reference to the case of Carl Zeiss, they say this helps them. Their submissions on this point are in the core bundle at tab 3, page 128, and a succinct summary of the case is in the learned judge's judgment at paragraph 158 in the core bundle tab 7, page 200. What they say, to an extent, is not disputed. It is uncontroversial that for private international law purposes there must be identity of parties or their privies as a condition of recognition of an in personam judgment. But Carl Zeiss, as the learned judge agreed, is not a case concerning in rem judgments, and therefore where it takes any of us is unclear. And the answer to this objection that they raise is to that which the learned judge alighted upon in her judgment, that the requirement of identity of parties falls away in the case of recognition of an in rem judgment. Now, my lords, my lady, those are our few submissions in reply. Unless there's anything else you would wish me to deal with, then I have nothing further to add.
Oh, well, thank you very much, Mr. Lissac. We're very grateful to everybody for the submissions which we've had. We will, I think it won't surprise you, reserve our judgments. When the judgments are ready, they will be circulated to the people whose names have been collected in the usual way. We will hope that in the light of what you read, you will be able to agree an order reflecting whatever we decide. And if you're unable to do so, we will have short written submissions and determine any issues without a hearing. You will be well aware, but I need to say it anyway, that when the draft judgment is provided to you, it is on the strict basis of the embargo, and as you also know, the court takes that very strictly these days. Well, as I say, we're very grateful to you. That concludes the appeal hearing.
And we are to the court. May I thank on behalf of all of us the court for facilitating this appeal being dispatched so swiftly. And we're very grateful to you all. Thank you.